My lord, the petitioner, my lord, he was lodged at a jail at Muzaffarpur, Bihar, my lord. And therein, my lord, he was there in the jail in connection with some cases. He got bail in all the cases. And my lord, one case was pending at Guwahati. And while he was at Muzaffarpur jail, protection warrant was issued under section 267 of the CRPC 1973. And on the strength of the protection warrant, he was
All cases are NDPS.
not some different cases, my lord. NDPS also, my lord, maybe.
Okay.
So, my lord, what happened, my lord? Protection warrant was issued, my lord, under section 267, my lord. And my lord, he was being produced regularly. And my lord, one fine day, my lord, the superintendent of jail at Muzaffarpur informs the court here that all cases against the present petitioner is over there, or he got bail. So, if needed, this court may take his custody. Now, my lord, there was only a protection warrant. The accused, the petitioner was never arrested. So, my lord, in normal course, my lord, the superintendent of jail, Muzaffarpur, he ought to have released the present petitioner from jail. Fact being that the warrant before him from the Guwahati court is not a custody warrant under 167 or 309, but it was only a protection warrant under 267. But the jailer did not do that. Then, my lord, the court here, my lord, when the jailer reported that all cases are over, the court at Guwahati ought not to have called the accused from there, my lord. This court directed that you bring the accused here, and then when he was brought, he was taken into custody, my lord. Now I'll take your lordship, my lord, to page 47. My lord. From here, I want to show that the when charge sheet was laid, my lord will see Pappu Kumar at Pappu Sahani at Pappu Kumar Sahani, not arrested. Page 47, order dated 2/4/22. The investigating officer of this case has submitted the offense report under section so-and-so of NDPS Act.
No, definitely, he can't be arrested. If the accused is not produced before the magistrate, he can't be sent to judicial to police remand, and therefore he is not arrested.
When an accused person is in jail in connection with some case, he will be shown arrested. He will be shown arrested, and the remand will be under section 167. But the investigating agency, my lord, did not arrest him. Neither arrested him nor shown arrest. So his position is not arrested. He was
shown arrest can be only when they come to the jurisdiction of the court. In connection with the case at Guwahati, one cannot be shown arrested there because he has to be produced before the magistrate and then shown arrest.
My lord, in any jail all over India, my lord, wherever the accused person is there, if he can be shown arrested, my lord. He has to be shown arrested in the connection with the case. Till the filing of the charge sheet, his position is not arrested. Till filing of the charge sheet, his position remains as not arrested. Now, my lord, page 49. Order dated 6/5/2022. Accused Pappu Sahani at Pappu Kumar Sahani produced through VC from Shahid Khurshidam Bose Central Jail, Muzaffarpur, Bihar, and remanded back till the next date fixed. Seen the letter submitted by the Superintendent Shahid Khurshidam Bose Central Jail, Muzaffarpur, Bihar, stating that all cases in regards to the accused Pappu Kumar at Pappu Sahani, son of Ramesh Sahani, pending in the local jurisdiction of Muzaffarpur, Bihar, have been disposed of, and that this court may pass directions for transmission of the said accused for physical production of the accused before this court. Issue production warrant in regards to the said accused for his physical production before this court on the next date fixed. Superintendent of Police Muzaffarpur, Bihar is directed to make arrangement for transmission of the said accused, namely Pappu Kumar at Pappu Sahani, son of Ramesh Sahani, from Shahid Khurshidam Bose Central Jail, Muzaffarpur, Bihar, to the Guwahati Central Jail, Guwahati, Kamrup Metro, for production of the said accused on the next date fixed. Inform accordingly. Now, my lord, 267, my lord. Section 267 of the CRPC, my lord. Mary 267, my lord. Power to require attendance of prisoners. Whenever in the course of an inquiry, trial, or proceeding under this code, it appears to a criminal court that a person confined or detained in a prison should be brought before the court for answering to a charge of an offense or for the purpose of any proceeding against him, or that it is necessary for ends of justice to examine such person as a witness, the court may make an order requiring the officer in charge of the prison to produce such person before the court answering to the charge or for the purpose of such proceeding, or as the case may be for giving evidence. When an order under subsection 1 is made by a magistrate of the second class, it should not be forwarded to or acted upon by the officer in charge of the prison unless it is countersigned by the chief judicial magistrate to whom such magistrate is subordinate. Every order submitted for countersigning under subsection 2 shall be accompanied by a statement of the facts which, in the opinion of the magistrate, render the order necessary, and the chief judicial magistrate to whom it is submitted may, after considering such statement, decline to countersign the order. Now, my lord, Section 267 does not give any power to the court to send the accused in a custody warrant. This is only a production warrant. Custody will be only under 167 and 309. Now, my lord, this present petitioner was, since he was not arrested, so the mistake was committed by the superintendent of Sahid Kursidam Bose Central Jail, Muzaffarpur, at the first instance in not releasing him. Now, my lord, against a prisoner, there may be many cases pending, but the superintendent of the concerned jail can hold him only with regard to the warrants which are in the nature of custody warrant under section 167 or under section 309 of the CRPC. The jailer cannot hold, if there is a production warrant under section 267, then the accused only needs to be informed that your next date fixed for so and so case in so and so court is so and so, and you appear there. That is how it is done, my lord. Here, my lord, he ought to have been released, but he was not released. Then a letter was written to the court here. Court have issued production warrant, and on the strength of production warrant, he was brought to Guwahati, my lord. And my lord, page 88, annexure 32. When he was brought, my lord, order dated 12/7/2023.
Page number
88. Annexure 32. May I read, madam? Case record is put up today before SPO is on transfer. Accused Papu Kumar Sahani is produced before me from Chhapra jail by SI Madhav Yadav of Chhapra Reserve Kendra on the strength of production warrant issued against him for production of the accused in the instant case. Sinda Bandhi Sithanantian Susna Patra. So whereby it appears that the accused person is medically examined in Chhapra jail. Accused person has been informed about his right to get free legal aid if he is unable to engage a counsel of his own himself. Intelligence officer C.S.K. Singh NCB has filed petition number 460 praying for remanding the accused person to the NCB custody for 3 days as the accused person is involved in interstate trafficking of illegal drugs and contraband, and his interrogation is of utmost necessity to determine the role and details of other persons involved in interstate trafficking of illegal drugs and contraband. Heard the special PP as well as the intelligence officer NCB. Peruse the case record and write order dated 2/4/22 of Honorable Session Judge Kamrup Metro Guwahati. It is seen that the offence report has been submitted against the accused under section so and so of NDPS Act by the investigating officer. Hence, in view of the same, prayer for custody of the by the NCB in connection with NCB crime number 20th of 2021 stands rejected. However, NCB may record the statement of the accused and do the necessary interrogation of the accused in the jail premises during the daytime in presence of the jail authority. Accordingly, accused Papu Kumar Sahani is remanded to judicial custody till 19/7/2023. So, my lord, what I am submitting is the order which I had shown, my lord, at page 49. This order, my lord, ought not to have been passed. Page 49. Here the wrong has been committed. Once the superintendent who is ignorant of the law that if there is no custody warrant and only production warrant is there, then the prisoner should be allowed to leave the jail premises, informing him of the next date fixed for the cases against him where production warrant are issued. The jailer was ignorant, the superintendent was ignorant, but the court here at Guwahati ought to have been diligent and would have exercised judicial mind and should have informed the superintendent of Said Khurshidam Bose Central Jail, Muzaffarpur, that the accused should be released. He cannot be kept in custody on the strength of production warrant. Since 6/5/2022, at best, my lord, maybe prior to that, but since order is there, 6/5/2022, he has been kept there at Muzaffarpur jail and produced before this court only on, as I have read just now, page 88, only on 12/7/2023, almost 10 months. Almost 10 months he was kept at Muzaffarpur jail only on the strength of production warrant under 267. There is one more aspect of the matter, my lord. Now, my lord, there is one more aspect of the matter, my lord. Now, my lord, my status was not arrested. Now, my lord, when I moved the bail application before the learned trial court, which the contention which I have forwarded before this court today, then, my lord, the bail application was rejected by order dated 16th of March 2024. Lordship will find the order from page 99. Page 99, my lord. And, my lord, I will take your lordship to page 114, which is a part of the same order, my lord. And the disturbing facts which comes up there, my lord, I'll read from page 114. Last paragraph, my lord, page 114. When the accused was first produced before this court on 12/7/2023, the NCB has submitted, my lord, my lord, may I read from decision and reasons for Papu Kumar Sahani from above, my lord? It is a matter of record that accused Papu Kumar Sahani was produced before this court on the strength of production warrant issued by this court. He was first produced before this court on 12/7/2023. No bail petition was moved for the accused on that day. The court remanded the accused to judicial custody. Whether the accused was sent to jail on production warrant or custody warrant, one thing is clear that the accused was taken by this court in his custody. Remanding the accused to jail hazard on production warrant and not on custody warrant will not automatically entitle the accused to bail. The final complaint was submitted on 31/3/2022. There is a petition in the case record signed by the IO dated 15/3/2022 praying to soon arrest accused Papu Kumar Sahani, but no petition number was assigned to the said petition and accordingly no order is also passed on the said petition. And for this reason, the accused Papu Kumar Sahani is shown in the final complaint as not arrested. When the accused was first produced before this court on 12/7/2023, the NCB has submitted second shown arrest prayer signed by the IO on 27/7/2023 and same is petition number 524 capital A dated 2/8/2023. No order on that petition number 524 capital A dated 0/2/8/23 is passed by my predecessor through inadvertent oversight. It is clear that NCB has moved required prayer for court to shown arrest accused Papu Kumar Sahani in this case. But through inadvertent oversight, order was not passed on the same by my learned predecessor. Hence, as per record, the accused Papu Kumar Sahani was not shown arrested in this case, though there is a prayer from the NCB for the same. Today, the prayer for shown arrest of accused Papu Kumar Sahani is allowed and petition number 524A dated 2/8/23 is disposed of. Now, my lord, on that day, my lord, after I raised the contention, on that day, learned court below is allowing the shown arrest. So, my lord, there are two things. Learned court below is saying that whether on production warrant or custody warrant, whatever warrant the accused is sent to the jail, he has been taken into custody. Now, my contention is, my lord, under production warrant, my lord, 267, there is no provision to take the accused person in custody. Under 267 says that only the accused can only be produced before the court and there is no question of any custody, my lord. That section 267 does not empower a court to take an accused person in custody under section 267, my lord. And my lord, the learned court below, my lord, have, my lord, shown arrested the accused person only on this date, my lord, 16/3/2024, my lord. Now, for a moment, my lord, assuming that his custody, my lord, from 16/3/2024, now his custody is under section 309, my lord. At best, it is 309, my lord. During inquiry or trial, he has been taken into custody. During investigation, then it is 167. Now it is during trial, it is 309. From 16/3/2024, his custody is under 309. But prior to that, my lord, entire detention is illegal, my lord. And my lord, when the initial detention is illegal, my lord, and if this court quashes that, my lord, everything else goes, my lord. My lord, there was no bar on the investigating officer to show arrest. If they have submitted a petition, there was no bar on their part to go and plead before the court that shown arrest order has to be passed. But nothing was done. They just kept the petition there, my lord. And my lord, we also do not know whether those petitions, when it was placed, we do not, but we are not doubting anything, my lord. But the fact is that no judicial order was passed on the petitions filed by the NCB. So, my lord, my status was not arrested only, my lord. So, my lord, this entire detention, my lord, of the present petitioner, which that he have undergone at Said Khurshidam, both central jail at Muzaffarpur, my lord, and thereafter, my lord, whatever detention he is undergoing here before in the Guwahati jail, my lord, central jail Guwahati, my lord, is illegal detention, my lord.
If that part is illegal, as you say, why not 482? Why criminal writ petition?
My lord, we have come, my
Because
lord.
the question of maintainability has been raised in the earlier proceedings. Question of maintainability is that's why we are asking you.
But this is illegal detention, my lord. Illegal detention, my lord. Habeas corpus will lie, my lord. Earlier also, lordship had allowed, my lord. My lord, in one instance, my lord, lordship had circulated the order to all the lower judiciary, my lord. When, my lord, the accused person, he was released on bail, during the COVID, my lord, and the magistrate said that that until and unless you complete the the period, my lord, which they are kept, my lord, for 14 days quarantine period, only after I am giving you bail, but you will submit bail bond after the quarantine period is over, after 14 days. Then we came to your lordship, that was during COVID, and lordship had allowed, my lord, that petition, that this is an illegal detention. Lordship interfered, my lord. Whenever there is a detention, illegal detention, court interferes, my lord, under habeas corpus writ, my lord.
Second is, now the trial court after all this has now taken him into custody as a during the pendency of the trial. So how can that be undone by way of a judicial order at this stage?
My lord, the law is, my lord, if the investigating agency, my lord, do not arrest during investigation, then during the course of trial, my lord, the court cannot take, my lord, the accused person into custody, my lord, in this manner, my lord. They have not come, they have not asked for to take him in custody, my lord. This is only a trial, my lord. And my lord, since the initial custody orders are illegal, my lord, everything goes, my lord. All subsequent acts, my lord, goes, my lord. They cannot correct a mistake which they have already done before. With any subsequent orders, my lord, that cannot be allowed to be corrected, my lord. And at what stage, my lord? This is a bail order, my lord. Order rejecting my bail petition. How can, my lord, when I am asking bail on that very point, learned court below is rejecting my bail by correcting its mistake, my lord? The learned court below had every reason to give me bail.
Proper petition should have been under 482. For saying,
My lord, we have come under habeas corpus because
there's a pronouncement not only by the Supreme Court also, but we have followed it and we have said in one of the cases that a writ cannot be issued against a court. It's a principle laid down by a constitution bench, 9 judges bench. It was a special bench. It says there cannot be a writ issued against a court.
my lord, but here, my lord, the writ will be also towards the.
No, but this order stands. We can't touch this order. That's a legal bar. That's the issue of maintainability.
Because, my lord, the wrong has been committed by the superintendent of Muzaffarpur jail also.
No,
Now, my
you see, that is
482
that is not within our jurisdiction. So therefore, that is a point we have heard it, but we can't touch it. Jurisdictional issues will come. We can't override the jurisdiction and hold and say something for a report which is not within our jurisdiction. But we will show you that judgment where
Well-
the Supreme Court has said that there can't be a writ issued against a court. Just wait. It's a long judgment to find out that specific. Yes, put this on. Citation is. Yeah, 1967 SC1. Hmm. Into para 123. Para 123. Just before that. No, just. Before that. Go up. Yes. Just one of the observations I have, since I don't have that much of time. 122 here.
Yes, my lord.
I dispose the result flowing of so and so says that the High Court or this court or the other courts so and so. And here is assumption to begin with. The High Courts cannot issue a writ to the Supreme Court because the writ goes down and not up. Similarly, High Court cannot issue it to another High Court. Writ does not go to a court or place of equal footing so and so. The court exercise part of so the court was wrongly issued to it. So now there is a discussion and somewhere it is stated because now it will be the opinion of another judge, Honorable Justice Shah. And then, but the end result is that the Supreme Court has held that a writ cannot lie to a court.
To a court.
Because a judicial act can only be corrected by way of an appeal. That is the finding here. But sorry, this short time, it is a long judgment. I can't find out the relevant paragraphs.
Now, my lord, we don't have option of appeal also because this is an
No, no.
interlocutory order.
No, that's okay. But the fact is that there is a 9-judge bench of the Supreme Court saying that. So therefore, this is a, we are not saying that we are closing this matter tomorrow. Since we are referring to a judgment, we'll give you an opportunity to make your submissions. But that is the point involved. The essence of this order is that an erroneous decision can be corrected by way of an appeal or a revision, but writ shall not lie. That is the sum and substance of this, but it's a long judgment. We can't waste our time.
My lord.
Sorry, not waste. It is spend our time to find out the relevant, because there's an opinion of 3 judges and then we'll have to collect out. This is what it is.
And my lord, I'll try to find out if there is any such judgment which says that if there is an illegal detention by a court's order, then habeas corpus lies.
No, then you see, then you will have to make some more submissions. You come to, you have a CRPC with you,
Yes, my
come to 461.
irregularities which vitiate proceedings.
And 460 is the 460 pre-page
Yes, four
is
sixty.
the irregularities which vitiate proceedings.
Yes, yes.
So now you'll have to also demonstrate that this order would also have the effect of uh, taking away the sting of the subsequent order where he was arrested during the course of trial as an under trial prisoner. So when do you want?
My lord, we'll give a try on Friday, my lord.
Friday? No, not Friday, because we have our programs.
My lord.
Uh, we
Any
take it
short date, my
Monday
lord,
or
as per the
Tuesday?
convenience of the
Monday or
court.
Tuesday?
Monday.
Tuesday?
Monday, my lord. Tuesday, my
Tuesday?
lord, Tuesday.
Huh?
Tuesday.
Tuesday. And what are the authorities you are relying on? You can give a list so that we can be prepared. If you are relying on your authority on the point.
As of now, I have not
Okay.
researched. Next day, I'll submit that. Copy of the thing.
Petition mentions.
Okay. So there is to overcome this, you may find a judgment of Kunayama. Spelling I would not remember. Kunnhyama, something like that. But that is of a smaller bench and would not be a good law. So Kunayama is distinguishable because of the fact that it did not. There is this 1967 would overline. Kunayama, something like that. Kunhha. I won't remember the spelling. So that is the only decision which runs counter to this Mirajkar. Sridhar Mirajkar. But I have my own reservations with that. It's not by a strength of more than 9 judges. And on the principle of precedence, we will follow the 5 judge bench decision in Pranay Sethi. So these are the things operating against you. But you have raised the question of maintainability. Just tell us what is the ground on the question of
First,
maintainability.
Lordship may see the parties. Only NCB and the state of Assam has been made parties.
Yes.
And secondly, Lordship may kindly see the prayer.
No, for that you see, Union of India is not a party, will not be so.
No, Lordship.
Ah.
And he was arrested in course of a regular proceeding, criminal proceeding. And London Trial Court has considered all aspects of the matter. And as observed by London or this honorable court, Lordship, habeas corpus will not lie. His remedy lies somewhere else. If any mistake has been committed, either by
No, that is one part. But the second part of the argument is that it will be once the order is the arrest is illegal, all subsequent continuation of arrest will fail. That is the argument being made.
submission of Lordship that has been corrected by London Trial Court in the order.
No, but illegality remains according to Mr. Khan.
The submission of my London friend is that initially the mistake was committed by superintendent of jail in Bihar, Lordship, not by this honorable court. Here mistake was
No,
that
shown arrest has to be there, but it will be
yes,
the
Lordship,
order.
that has been explained by the London Trial Court. That the NCB has filed 2 applications. And inadvertently no order could be passed. Subsequently, it was corrected. Now, see page 115. London Trial Court has taken note of notes.
Obliged, my lord.
Krishna, as well as Mr. Ezekiel, and standing also for the NCB, and Mr. HK Hazarika, and government advocate, preparing for respondent one. No, you're for state of Assam.
State of Assam.
No, this is a writ petition. So therefore, it doesn't matter. We just have to record your presence. Next matter. On the issue of maintainability, the Learned Counsel for the petition is granted some more time to address the court. Next matter, list on, make it 6th, 6-8.
Obliged.